morning and welcome back to another episode of Law Schoolers. In this episode, we are continuing to discuss secure transaction and enforcement. And today we are going to be talking about enforcement against tangible collateral. In other words, how do you recover collateral that is secured by the secured agreement? So we're going to be focusing on recovery, disposition, notice requirement with all that, and how this process is supposed to work. So let's start by talking about recovery. Well, recovery can occur either through a judicial or non-judicial process. Non-judicially, the secured party has a right to go and repossess without a court process as long as there is no trespass violation and the repossession proceeds without a breach of the peace. So, how do you determine whether or not there is a breach of the peace? Because ultimately, in other words, you can, without going to the court, go and repossess the collateral as long as there's no trespass or breach of the peace. So breach of the peace, there's a couple of different potential rules that apply here. The first rule that we have is if a creditor repossesses in disregard of the debtor's unequivocal oral protest, the creditor commits a breach of the peace. That's found in Russell versus Santana Consumer USA. Ultimately, what that is just saying is if the debtor says something, no, you can't take this, well then you have to go to the court, because if you continue to take it with that oral protest, there's a breach of the peace. That's one rule. What is the second rule? Well, the courts are going to consider several factors. Whether there's violence, where did the repossession take place? When did the repossession take place? Did the debtor provide express or constructive consent to the repossession? What was the reaction of third parties that witnessed the repossession? What was the type of the premises entered? Was it exterior? Was it interior? Did the creditor use deception or gave the impression of authority when repossessing the collateral? Ultimately, those are things that are going to be considered, but noise and commotion are not going to be sufficient to determine whether or not there is a breach of the peace. And that is the second rule. We're going to look at violence, the location, the time, consent, reactions, and location, and whether or not there is any deception. Those ones are found in Giles versus First Virginia Credit Services Incorporated. So that's really what recovery is through the non-judicial process. Don't breach the peace. If you breach the peace, depending on your jurisdiction, whether there's an oral protest or considering these other factors. Now, what about disposition? Well, disposition refers to when the secured party either sells, leases, or licenses the recovered collateral, and typically disposition is going to occur by a public or private sale. So, if you are going to engage in disposition as the creditor, there are a few things that needs to be done to make this a legal disposition. You need to provide proper notice, you need to follow commercial reasonableness, and then you need to manage proceeds in the proper way. Let's start with notice. Article 9, Sections 961 through 9614 describe how notice is supposed to be provided. And the purpose of notice is to provide the debtor with enough information to exercise their rights and attempt to recover the collateral either through redemption, which we talked about in the last episode, paying the debt in full, or they can bid on it, or any other rights that they have at this public auction that would allow them to recover the collateral. So you need to be provided with enough notice. What is considered sufficient notice is going to be a letter that is sent to the debtor and then some other individuals who might be interested parties in the collateral if there's subsequent creditors. This notice in the letter that is sent to the debtor and potential other creditors must determine who needs to be contacted, because there are several parties who may be required to show. It needs to state that the debtor is free to redeem by paying the balance of the debt, and it needs to indicate the anticipated date and the method of disposition. Now notice that is the anticipated date. It does not need to actually occur on that date, but it does need to say when we expect it to happen and how we expect it to happen. So what about commercial reasonableness? Disposition must be commercially reasonable to be considered legally effective. Depending on the action taken, several factors are going to be relevant here. For example, courts are going to need to consider the time and the location of the sale or auction. And they need to consider whether the sale should have been public or private. Should have been, not whether or not it was public or private. And how the sale or the auction was advertised. And then finally, it needs to look at the price of the collateral and some other factors that are outlined in Article 9, Section 9, 610B, and then the comments 3 and 4 related to that, and also Article 9, Section 9, 627B. A low price may be considered unreasonableness. When I say a low price, meaning typically a lot of the time nobody shows up to these auctions, and including the debtor, because most of the time the debtor can't redeem the collateral because they don't have enough money to pay it off anyways, hence why it was repossessed in the first place. So most of the time, there's not very many people there who are going to be present at this auction. Typically, the person or organization that will be present at the auction is going to be the company or the creditor who ultimately had recovered the collateral in the first place. So they could even give a discounted price on the collateral, because now you need to decide what happens with those proceeds, because the proceeds goes towards paying off the debt, and also anything left over goes to the debtor and other creditors that have priority. So what is going to happen here, a lot of the time creditors will put forward a pretty low bid on the collateral and to essentially get this collateral for a discount. And if it's low enough, that may indicate unreasonableness in this auction. But a low price is not going to be deterministic of whether or not it is commercially reasonable. But when courts do see a low price, the other factors that we had just talked about are going to be considered much more carefully, because it's like a little red flag going off. It's going to alert the courts, hey, something might be a little off here. Let's look at how everything else ended up going down. Okay, so commercial reasonableness, so step 1 was recovery. Step 2, disposition. You provided notice of the sale. Commercial reasonableness, you go through the sale. What do you do with the money that you receive as a result of selling this collateral at this private or public auction? Well, Article 9, Section 615 is going to outline the rules for how cash proceeds are going to be distributed. There is an order of operations as to who gets paid first after disposition is made and how cash proceeds are received. So who gets paid first? First, all the expenses of repossessing in disposition. You're going to pay off the repo agent first. The second person who gets paid, and first also the repo agent and the lawyer who ended up going through the disposition. Anyways, lawyers get paid first. That's ultimately the takeaway there. The second person who gets paid is the foreclosing secured party. So the person who foreclosed on the collateral, the person who pulled the trigger and actually foreclosed and recovered the collateral. The third party who's going to get paid are junior security interests. So if there were multiple creditors, anybody junior to the foreclosing party will be paid next. Now, this is important to note because sometimes a junior creditor forecloses before a senior creditor. So that senior creditor doesn't get paid, but they still have a security interest in that collateral. So if something else happens, then that other party, the senior party, could foreclose then too. Anything that is left over is going to go to the debtor. Is there anything typically left over? No, not usually. Most of the time, it's all paid off for the foreclosing secured party, and typically junior security interests, if there are any other creditors, typically don't get all of their share anyways. And so that means that the debtor being left at the bottom of the pile is not likely to get much left over because the sale of the collateral did not exceed the amount of debt that they had paid off. That kind of thing. If the sale of the collateral is not enough to cover the foreclosing party's requirement, this is something we'll talk about later, but the foreclosing party may still have a claim against the debtor for having an insufficient amount of collateral, and a judicial lien may be placed against the debtor for the remaining debt that is put there. So sometimes purchases are made on credit rather than cash. So what I just outlined was what happens if there's cash. But if these purchases are made in credit, well, then the secured party may either turn the collateral into a new security interest for the new debtor, or they wait until they are paid in cash once the obligation is satisfied. What I mean by the obligation is their debt is satisfied. What the creditor had paid out, they receive back. The result of a sale of collateral is that the buyer takes the item free and clear of any security interest the foreclosing party and any junior party has on that collateral. Note that this is free and clear of any foreclosing and junior party. If there was a senior party, they do not take that collateral free and clear of the senior secured party. In that situation, the purchaser takes the collateral subject to a security interest of the secured party who is senior to the foreclosing party. Okay, so that's everything that I want to wrap up with today. We just talked about enforcement of tangible collateral items that you can feel. We talked about recovery, the requirements there, making sure there's no trespass or a breach of the peace, and we talked about what it means to breach the peace. We talked about disposition, which is the sale of the collateral after it has been recovered, and the steps for going through that. You need to provide proper notice. The sale needs to follow commercial reasonableness standards. And then who gets paid after the sale had actually happened? How do you manage the proceeds of that sale? So those are all the things that we talked about in this episode. Next episode, we are going to be talking about full and partial acceptance of collateral to satisfy the debt. But we'll expound more on that next time. Thanks for listening. I'll talk to you all later. Have a good one, and bye. Thank you for listening to this episode of the Law Schoolers Podcast. If you enjoyed the show or the material shared on the Law Schoolers website, you can support Law Schoolers by becoming a patron at patreon.com/lawschoolers. I also wanted to provide a quick disclaimer. Nearly all Law Schoolers material is unedited due to the sake of time and a desire to keep the content as raw as possible. Additionally, the material is only provided for educational purposes and is not to be used as legal advice. If the material is used as legal advice, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show.